Welcome to Law Made Simple, your trusted space for legal clarity and public empowerment. Today's episode is for anyone who's ever felt misled, confused, or trapped in a check bounce case. You trusted your lawyer. You followed their advice. But now, you're the one facing consequences. Fake promises, vague strategies, courtroom delays, these aren't just frustrating, they're dangerous. We're going to unpack how accused persons often get misguided in Section 138 NI Act cases. We'll show you the red flags, the legal truths, and how to protect yourself from emotional manipulation. Because in the end, it's not the advocate who pays the price, it's you. This episode is not just about law, it's about accountability, awareness, and self-protection. We'll walk through real examples, preventive tips, and smart steps you can take today. Whether you're facing a case or supporting someone who is, this knowledge matters. We believe legal literacy should be simple, accessible, and actionable. So if you find this helpful, share it with someone who needs it. And don't forget to like, share, and subscribe to Law Made Simple. Let's begin with the legal foundation. Section 138 of the Negotiable Instruments Act deals with dishonored checks. If your check bounces and the complainant proves basic facts, you could face criminal charges. The punishment? Up to 2 years imprisonment, or a fine that may be double the check amount. But here's the twist, once you admit the check was yours, the burden of proof shifts to you. You now have to prove that there was no legal liability, or that the check was misused. This is where many accused persons get misled by their lawyers. They're told to deny everything, delay the case, or confuse the court. But denial without evidence is not a defense, it's a trap. Judges are trained to spot vague tactics and procedural stalling. Section 139 creates a presumption of liability unless rebutted with credible proof. So if you don't prepare a proper defense, the law will presume you're guilty. Understanding this legal structure is your first shield. Don't rely on charisma or courtroom drama, rely on facts, documents, and timelines. Let's now explore how misguidance actually plays out in real cases. Let's talk about the most common ways accused persons get misled. We'll drag the case for years, the complainant will give up. Just deny everything, even the check, even the signature. Don't reply to the legal notice. It's just a formality. We'll settle later. No need to prepare now. These are not legal strategies, they're shortcuts. And shortcuts in criminal law often lead to disaster. Delaying the case doesn't weaken the complainant's evidence. Denying the check without proof can backfire badly. Ignoring the legal notice can be seen as evasive behavior. And postponing preparation means you'll be exposed when trial begins. Many advocates use these lines to sound confident, but confidence isn't competence. You need a lawyer who gives you a written strategy, realistic timelines, and honest expectations. Let's now look at a real example where denial led to conviction. Meet Mr. Ramesh, a small trader from Pune. He issued a check to a supplier, but it bounced due to insufficient funds. His lawyer advised him to deny everything, deny the check, deny the transaction. No need to admit anything, the lawyer said. We'll confuse the court. But the bank confirmed the signature. CCTV footage showed the check handover. The complainant had WhatsApp chats and delivery records. The court presumed liability under Section 139. Ramesh had no documents, no timeline, no defense. His lawyer had no backup plan, just vague arguments and procedural delays. The judge saw through it and convicted Ramesh. The lawyer shrugged, we'll appeal. But Ramesh was left with a criminal record, financial loss, and emotional stress. This is why blind denial is dangerous. You must prepare a real defense, not just rely on courtroom theatrics. Let's now talk about how emotional manipulation plays a role. Many accused persons fall into the emotional trap set by overconfident advocates. Don't worry, I've handled hundreds of check bounce cases. I know the judge personally. We'll manage. But where's the written strategy? Where's the timeline? Where are the documents, the witness prep, the backup plan? Advocates often use emotional manipulation to gain trust. They smile, they reassure, they promise outcomes they can't guarantee. They avoid hard questions and skip real preparation. And when things go wrong, it's the accused who suffers, not the lawyer. Your liberty, your reputation, your finances, they're all at stake. Don't get swayed by charisma. Ask for clarity. Ask for accountability. Ask for a plan. Because when the trial begins, vague promises won't protect you. Let's now talk about how to protect yourself. If you're accused in a check bounce case, here's how to protect yourself. Step 1. Demand a written strategy and timeline from your lawyer. Step 2. Respond to the legal notice with facts and evidence. Step 3. Preserve your bank records, WhatsApp chats, and transaction history. Step 4. Ask for realistic outcomes, not vague promises. Step 5. Attend hearings, ask questions, and stay involved in your case. Don't rely on your lawyer alone, take ownership of your defense. Prepare your documents early. Identify witnesses. Build your narrative. Ask your lawyer to explain the presumption under Section 139 and how you'll rebut it. Ask for a checklist of what needs to be done before trial begins. Legal literacy is your best protection. And Law Made Simple is here to support you every step of the way. Let's wrap up with a final message. In a check bounce case, your future is on the line. Don't let fake smiles and vague promises misguide you. Demand clarity, preparation, and accountability, because when things go wrong, it's not your advocate who faces conviction, stress, or financial loss. It's you, the accused, who bears the burden. So ask questions. Insist on written strategies. Preserve your evidence. Don't settle for shortcuts or courtroom drama. Legal defense is not theater, it's documentation, timelines, and truth. And if you've already been misled, it's never too late to take control. Law Made Simple is here to help you navigate the noise and focus on what matters. We break down complex laws into clear, actionable steps. We believe legal literacy is not a luxury, it's a necessity. So if this video helped you, share it with someone who needs it. A friend, a colleague, a family member, someone who might be silently struggling. Like the video. Share the video. And subscribe to Law Made Simple. Because justice begins with awareness, and awareness begins with you.